And a very warm welcome to all of you to lectures by Professor Dr. Shilpa Khatri. Today's lecture is in continuation of the series of lectures on lawyers as social engineers. And today we are primarily going to be speaking about the views and perspectives of Jeremy Bentham. Coming from the classical school of law, Bentham is very similar to the other classical theorists who belong to that particular school, who were arguing that the human conduct is guided by a principle of economic rationality, by weighing the anticipated costs and benefits of action alternatives. Accompanying this conception is the notion that people are free and should therefore be held accountable for their own actions. Under such conditions, law should emphasize due process requirements to establish guilt or innocence, with minimal government intrusion, and a primary deterrent function be assigned to punishment. Among the key proponents of the classical school, other than Jeremy Bentham, is also Cesare Beccaria. And before we move on to Bentham, I would like to briefly discuss Beccaria here, the Italian political philosopher who opposed capital punishment on the grounds that the state cannot legitimately claim the right to take lives. And because the death penalty is neither necessary nor useful. The reasoning he argues behind this is that the contention being that capital punishment does not have a deterrent effect towards the wrongdoers, for it is not the severity but the certainty of the punishment that determines its deterrent impact. Influenced by the idea of social order as a contract, Beccaria thus defended the idea that the main function of state is to enforce laws that limit a boundless pursuit of self-interest. For such laws to be effective, they need to be made public so they are widely known and involve swift and certain forms of punishment that increase the relative cost associated with a violation of law. Offering a more systematic formulation of the utilitarian framework, the British philosopher Bentham developed a political and legal philosophy on the basis of the principle of economic rationality, that human conduct is guided by a search for pleasure and an avoidance of pain. He applied his utilitarian philosophy to law to argue that the legal system should be founded on the principle to provide the greatest possible happiness to the greatest possible number of people. Bentham formulated the principle of utility, which approves of an action insofar as an action has an overall tendency to promote the greatest amount of happiness. Happiness being identified with pleasure and also with the absence of pain. He defined as the fundamental axiom of his philosophy the principle that it is the greatest happiness of the greatest number that is the measure of right and wrong. Bentham claimed to have borrowed this concept from the writings of Joseph Priestley. Bentham's ambition in life was to create a panomion, a complete utilitarian code of law. He not only proposed many legal and social reforms, but also expounded an underlying moral principle on which they should be based. And that was the above mentioned fundamental axiom according to Bentham. Now, his theory of human behavior was guided by the hedonic calculation. What is hedonic calculation? It is a method of working out the sum total of pleasure and pain produced by an act. Thus, what are we working out? We are working out the total value of its consequence, also called the philosophic calculus. Bentham sketched this in chapter 4 of his work titled Introduction to the Principles of Morals and Legislation, published in 1789. He argued that to judge whether whether an action is right or wrong, one should consider the pleasures and the pains resulting from it. The pleasures and the pains should be considered in respect of a couple of factors like the intensity or the power, the duration, the certainty, the propinquity or the proximity, the fecundity or the productiveness, measured by the chance that a pleasure is followed by another pleasure, or maybe a pain is followed by another pain. Also, in terms of purity, which should be seen as the chance that the pleasure would be followed by pain and vice versa. And finally, the extent, that is the number of people who are affected. Now, all alternative courses of action must be viewed in the above contexts, which we have just showcased, and he believed that this method will determine which act has the best tendency and therefore is right. Complementing the theory of human behavior as guided by the hedonic or the philosophic calculus to maximize utility from the individual's perspective is thus a theory of society on the basis of social calculation. Social calculation for what? To maximize utility from the aggregate point of view. For Bentham, the law provides the basic framework of social interaction by delimiting spheres of personal inviolability within which individuals can form and pursue their own conceptions of well being. It provides security, it provides a precondition for the formation of expectations. To ensure an egalitarian society, Bentham argued broadly five steps which need to be fulfilled. One, which is the equal and fair application of laws. Second, which is a due process requirement which needs to be obeyed before a person could be found guilty or innocent. Third, evidence had to be investigated. Fourth, judicial discretion had to be minimized by limiting the power of the judge only to the determination of whether there is guilt or there is innocence. Punishments were to be based on a calculation of pleasure and pain. He reviews the concept of punishment very interestingly and when it should be used as far as whether a punishment will create more pleasure or more pain for a society. He calls for legislators to determine whether punishment creates an even more evil offense. So instead of suppressing the evil acts, Bentham argues that certain unnecessary laws and punishment could ultimately lead to new and more dangerous vices than those being punished to begin with, and calls upon legislators to measure the pleasures and pains associated with any legislation and to form laws in order to create the greatest good for the greatest number. And lastly, justifying circumstances associated with a legal violation and its penalties. Now, Bentham at first believed that the enlightened and the public spirited statesman would overcome conservative stupidity and institute a progressive set of reforms to promote public happiness. Well, but when disillusionment set in, he developed a greater sympathy for democratic reform and an extension of franchise. Interestingly, also, he believed that with the gradual improvement in the level of education in society, people would be more likely to decide and vote on the basis of rational calculation of what would be for their long term benefit, and individual rational decision making would therefore, in aggregate, increasingly tend to promote the greater general happiness. Now, he argues that the concept of the individual pursuing his or her own happiness cannot be necessarily declared right. Why? Because often these individual pursuits can lead to greater pain and less pleasure for a society as a whole. Therefore, the legislation of a society is significant, is vital, is important to maintain the maximum pleasure and the minimum degree of pain for the greatest number of people. In fact, Bentham was the first person to aggressively advocate for the codification of all the common law into a coherent set of statutes. He was actually the person who coined the verb to codify to refer to the process of drafting a legal code. Bentham said that it was the placing of women in a legally inferior position that made him choose at the innocent age of 11 the career of a reformist. He spoke for a complete equality between both the males and the females. And in fact, he went beyond, and in the essay titled Offenses Against One's Self, he argued for the liberalization of laws prohibiting homosexual sex. For Bentham, transparency had moral value and wanted transparency to apply to everyone. This he describes by picturing the world as a gymnasium in which each gesture, and I'm quoting him here, every turn of limb or feature in those whose motions have a visible impact on the general happiness will be noticed and marked down, thus considering both surveillance and transparency to be useful ways of generating understanding and improvements for people's life. With this, we come to an end of lectures on lawyers as social engineers from the perspective of Jeremy Bentham. However, we shall continue with these series. Happy learning to all of you.